Hello, and welcome to UK Employment Law, the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights recent case law and legal developments of importance to UK employers. It is presented by members of Mayor Brown's employment team and occasionally features special guest speakers who are involved in changes in employment law. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions. We hope you enjoy the podcast.
Hello, my name is Chris Fisher and I'm the head of the London employment team at Mayor Brown. This is episode 201 of Mayor Brown's UK Employment Law podcast, A View from Mayor Brown. Now, as those of you who've listened to the last few episodes of the podcast will know, I'm taking over responsibility for the podcast from Nick Robertson, who left the firm at the end of last year. And although I hopefully won't be the only member of the team presenting episodes from time to time, I'll do my best to do justice to the tremendous work that Nick put into the podcast over the past 200 episodes. And hey, my friends have always said I've got a face for radio, so I think I'm off to a good start. Right then, the two cases I have for you on this episode relate to a case, first of all, on discrimination law remedies, and then a case about covert surveillance. So my first case is Steer versus Stormsure Limited, which is an EAT decision handed down just before Christmas. And it's one, I think, with potentially huge significance for employers. It's all about the remedies that can be granted in discrimination claims where a claimant has been dismissed. At the moment, under the Equality Act, the main remedy a claimant can hope for is compensation if they win at the final hearing. But the question in Stormsure was whether our UK law should go further than that and allow what is known as interim relief when someone has been dismissed for a discriminatory reason. Interim relief, where it's given, essentially means that the claimant employee who's been dismissed is reinstated or re-engaged, or, more commonly, they have their employment contract continued so that they receive pay and benefits until the main hearing of the claim comes on, but they don't have to work, they don't return to work. At the moment, the only dismissal claims where interim relief is available are whistleblowing cases or where the dismissal is because of trade union membership or certain other specified activities. But it's not available where the dismissal is on grounds of discrimination. So, in Steer and Stormsure, Mrs. Steer worked for Stormsure for a short period during 2020, just a period of a few months. After she joined them in March, she raised a grievance over alleged sexual harassment by a colleague. She claimed that that was not adequately investigated and then asked to work from home to avoid further harassment from happening. She said Stormsure reacted badly to the sexual harassment grievance and badly to the request to work from home, and things deteriorated from there to a point where she ended up leaving and claiming constructive dismissal. She alleged that the dismissal amounted to sex discrimination and victimization based on the adverse reaction to her grievance and the request to work from home. So she submitted her tribunal claim, and at the same time, unusually, she made an application for interim relief. Unsurprisingly, the Employment Tribunal initially declined to hear the application as it simply wasn't available under the Equality Act. But with the support of the Equality and Human Rights Commission, Mrs. Steer appealed and the issue ended up in the EAT on the 15th of December last year. There were essentially two parts to Mrs. Steer's argument. The first one related to European law. Mrs. Steer argued that the failure of our domestic UK law to provide interim relief in discrimination cases is a breach of EU law, specifically the EU law principles of effectiveness and equivalence. So that was the first part of her argument. The second limb of the argument related to the European Convention on Human Rights. And Mrs. Steer argued there that the lack of interim relief in UK discrimination law is a breach of the convention unless it could be justified by the UK government. And she said it couldn't be justified in this case. So just to talk a little bit more about these two limbs, the comparison Mrs. Steer was drawing in both cases was between the UK discrimination law and the UK whistleblowing law, and the protection that each of those laws gives to employees who are dismissed. Now, where the employee is dismissed on grounds that they've made a protected disclosure, the whistleblowing law allows an interim relief application to be made, but no such remedy is available to an employee who's dismissed on discriminatory grounds. So that was the unfair comparison that Mrs. Steer was pointing to. So what was the outcome? Well, very briefly, and I'm summarising here a very long judgment by the EAT, but Mrs. Steer lost on the European law point, but she was successful, sort of, on the human rights point. As far as the European law principles were concerned, the EAT ultimately found that there was no breach. First of all, on the effectiveness principle, they said that they didn't think interim relief was necessary for discrimination rights to have an effective remedy in UK law. They said that there is already sufficient remedy under our discrimination law because claimants can recover compensation if they succeed at the main hearing of their claim. And that should be enough, the EAT said. So that was effectiveness. On the equivalence principle, they said, on balance, Mrs. Steer was unsuccessful again, but it caused them slightly more difficulty. And the equivalence principle is the principle that says the procedures and remedies for claims that are derived from EU law must be no less favourable than those that apply to similar actions under domestic law. Now, as I've said, the similar action in Mrs. Steer's case was, she said, a whistleblower dismissal claim. And the judge agreed that the whistleblowing dismissal claim was a similar action for these purposes to a discrimination claim resulting from a dismissal. But, he said, when you compare the procedural rules and remedies as a whole, then the ones that are available under the discrimination law are actually no less favourable. So Mrs. Steer lost on that ground as well. So she didn't succeed on her European law argument, but she did significantly better under her human rights argument. Now, on that one, she pointed to Article 6 of the European Convention on Human Rights, which grants the right to a fair trial. And then she combined that with Article 14, which says that the rights under the Convention must be capable of being enjoyed without any form of discrimination. The discrimination Mrs. Steer pointed to was between the two different individuals who might be looking to bring a claim of dismissal or victimisation arising out of a dismissal. The comparison, she said, was between someone like her, claiming that their dismissal was discriminatory, and someone bringing a dismissal claim under the whistleblowing law, claiming that their dismissal was by reason of a protected disclosure. In one case, interim relief is available for whistleblowers, and in the other, it isn't. Now, the EAT accepted that this was a valid comparison, and so under the convention, the question then became whether there were differences between these two categories of claim which justify the availability of interim relief for one but not the other. So here, on this point, Mrs. Steer was shooting into a bit of an open goal because no justification was put forward for why our discrimination law and whistleblowing laws differ as regards interim relief. And that was because the government didn't put forward any justification. They weren't part of the proceedings. The government legal department had been invited to intervene in the case, but had not done so. And to be fair, I imagine they are fairly busy at the moment with other things. But what that meant was that there was no one at the EAT hearing who could put forward any justification for why Parliament has decided not to include interim relief in the Equality Act, whereas they have included it in our whistleblowing law. So, as a private employer, Stormsure could only guess at why that might have been the case, so they weren't able to put forward any reasons themselves. So the EAT concluded that the difference in treatment was indeed a breach of the European Convention on Human Rights. So what does all that mean? Well, at the moment, for Mrs. Steer, it doesn't really mean very much. The EAT doesn't have the power to make a declaration that the Equality Act is incompatible with the European Convention. So the case will now have to go to the Court of Appeal. If the Court of Appeal agrees with the EAT on the European Convention point, then they are in a position to grant a declaration of incompatibility, and the UK government will then have to amend our discrimination law to introduce the availability of interim relief. If that happens, it's undoubtedly hugely significant. The inclusion of interim relief as a remedy in discrimination law has the potential to change the whole landscape of discrimination claims. It's fair to say that interim relief applications are not easy for claimants to make, or indeed to be successful in. First of all, if you take the whistleblowing process, the application has to be made within 7 days of the dismissal, not the usual 3 months. And the standard of proof is very high. The employee has to show that they are likely to win their case at the final hearing. Or, to put it another way, they have to have a pretty good chance of success. So, not easy, and a claimant would have to spend potentially significant legal fees to bring an interim relief application. They are a bit like applying for an interim injunction. But if they're successful, it's massively effective. As I mentioned before, the employee is either reinstated in their old role, re-engaged in a new one, or, more likely, they'll simply have their contract continued for pay and benefits purposes without having to work. And here's the real significance. If the employee later loses their claim when it finally gets to a main hearing, they don't pay back any of that money. Now, I'm sure many of you are experiencing the horrendous delays in the tribunal system at the moment. I know we certainly are here at Mayor Brown. In its judgment, the EAT referred to there being around 37,000 outstanding cases in the tribunal system at the moment. And the COVID pandemic is undoubtedly creating havoc. And although virtual hearings are happening, the backlog is causing cases to be postponed by well over a year, multiple years in some cases, in my experience. So if you're an employer and you've just lost an interim relief application, you are bound to move immediately into settlement mode to try and mitigate in some way the losses that you are going to suffer. Because, as I say, you will not recover the pay and benefits that you have to pay to the employee, even if they are unsuccessful at the ultimate hearing. And a final point for those of you wondering if this case will be affected by Brexit, well, it won't, because Mrs. Steer won under the European Convention on Human Rights, which is not affected by the UK's departure from the EU. And it does seem ironic that while many of us were wondering whether the UK government might peg back discrimination law at some point in the future after Brexit, there had been a suggestion by some that the cap on discrimination compensation might be reintroduced. Quite the contrary, it seems that we now have the prospect of a significant extension to our discrimination law being made. So that's Steer and Stormsure, and I think saying that the upcoming Court of Appeal decision is one to watch is something of an understatement on that one. The other case I wanted to talk about is Gerrard against Eurasian National Resources Corporation and Diligence International. This is a High Court judgment handed down again before Christmas, and it's about covert surveillance and the Protection from Harassment Act 1997. It's interesting because it's being described by some as the death knell for covert surveillance in the context of litigation. And although the case didn't involve surveillance of an employee by their employer, it applies very much to the employment scenario as well. As we hear reported, in our current remote world of work, employers are carrying out increasing amounts of monitoring of their employees' working patterns at home. And so I think this case is timely and one to bear in mind. Now, the case is actually part of a much wider dispute between Mr. Gerrard and Enrc, which relates to when Mr. Gerrard acted as a solicitor instructed by Enrc to carry out an investigation into some of their subsidiaries' activities. And he did that investigation between 2010 and 2013. The wider dispute concerns a claim brought by Enrc against Mr. Gerrard for damages for breach of fiduciary duty and negligence. They say that during the course of the investigations he was carrying out, he breached those duties that he owed to his client, Enrc, because he encouraged the Serious Fraud Office to intervene in the investigations. And Enrc say he did that simply to generate additional legal fees, and that was a breach of his duty. So as part of their preparations for the litigation, Enrc is alleged to have carried out extensive covert surveillance of Mr. Gerrard and his wife over a number of years, dating back to 2013. As part of that surveillance, Enrc instructed a private firm of investigators called Diligence, and Diligence is the second defendant in the case. The claim that Mr. and Mrs. Gerrard have brought alleges various breaches of data protection law and harassment under the Protection from Harassment Act 1997. The application that was decided by the High Court before Christmas was an application by Enrc and Diligence to strike out the harassment claim because they said it had no reasonable prospect of success. The Protection from Harassment Act, or the PHA, as I'm going to refer to it, is often known as the anti-stalking legislation. And it's true that that's one of the forms of harassment that it's designed to prevent. But it's drafted much more widely than that. The PHA simply says that a person must not pursue a course of conduct which amounts to harassment of another person and which he knows or ought to know amounts to harassment of that other person. Now, harassment is said to include alarming the person or causing the person distress. So, very simple set of definitions. There are then certain exceptions that apply, and that includes where it's reasonable to pursue the course of conduct in question. And where that's the case, there won't be a finding of harassment. Where there is a breach of the PHA, it gives rise to civil liability, which can result in a claim for damages or an injunction to restrain the harassment from continuing. And it also can give rise to criminal liability. So what was the basis of Enrc's strikeout application? Well, they relied largely on the fact that the case law that has followed the introduction of the PHA has made it a requirement for the conduct in question to be calculated to produce the necessary alarm or distress. Now, they said that any surveillance that they had carried out couldn't amount to harassment because it was always intended to be covert. So Enrc said, surveillance which is intended to be covert and not discovered can't be calculated to cause the person distress. The High Court disagreed. Having reviewed various cases involving PHA claims, the judge said that it wasn't necessary for the perpetrator to intend to cause distress. He said that it was enough if the conduct was sufficiently likely to cause distress in all the circumstances. And that could be the case whether the surveillance was covert or not. His view was that if covert surveillance was excluded from the PHA, then the protection the Act gives would be hugely diminished. He gave the example of a victim of surveillance who's been secretly watched on 6 occasions and only realises what's happening on the 7th time that they're being watched. And at that point, the distress is caused. The judge said, well, if you take Enrc's argument, then there's no course of conduct there for harassment purposes because no alarm or distress has been caused on any of the initial 6 occasions. And a single occasion of harassment cannot amount to a course of conduct. So there would be no claim because you'd have to ignore all of the covert incidents of surveillance. So he disagreed with Enrc's arguments. And finally, he commented on their suggestion that including covert surveillance as potential harassment under the PHA would sound the death knell for surveillance firms and their activities. And he didn't accept that suggestion. First of all, he referred to the fact that the PHA has an exception where the conduct in question is reasonable. And secondly, he referred to the fact that the legality of covert surveillance often comes up in other contexts, not in relation to the PHA, but under the privacy laws and the European Convention on Human Rights. He referred in particular to a 2011 German case of Kepka, and in that case, covert video surveillance was set up in a supermarket because it was suspected that shop workers were stealing drinks. And one of the shop assistants was dismissed as a result of the video evidence that was obtained and brought employment proceedings in the German courts. And that ultimately made its way up to the European Court on Human Rights. The court took account of the intrusion into the employee's privacy rights, but balanced it against the employer's convention rights, in particular the right to protection of property. In the end, the court came down in favour of the employer because of the relatively limited extent of the covert surveillance they'd carried out. It had only been carried out once potential criminal activity had been detected. It was only carried out over a limited period of time, 2 weeks, and it was restricted to a specific area in the shop. And finally, it was targeted at 2 particular employees who were under suspicion. So the judge's conclusion in the Gerrard case was that it was perfectly possible to carry out surveillance, including covert surveillance, which is lawful from a privacy, a human rights perspective, as much as under the Protection from Harassment Act. Whether the surveillance was lawful or not in the Gerrard case will now be decided when the case goes to a full hearing because the judge refused to strike out the claim. So in the meantime, I think the case is interesting. As I say, it's an illustration of how the Protection from Harassment Act can apply to employers carrying out surveillance in relation to their employees. Often, I think where employers consider surveillance and monitoring activities, they'll be thinking primarily about the data privacy rights of the employees. But this is a good reminder, I think, that in addition to that, they need to be thinking about employees' rights under the Protection from Harassment Act. So that's the case of Gerrard and Enrc, and that marks the end of my first podcast. I hope you enjoyed it. As always, if there are any questions, please feel free to contact us. And until next time, I hope you all stay safe and healthy. Thanks very much.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions, or want to know how to claim continuing education credits, please email Christopher Fisher, Head of Mayor Brown's London Employment Team, at cfisher@mayorbrown.com. Thank you for listening to the podcast.